COM. It's that he committed, what was that? Oh, no, I'm sorry. They dismissed it. It was an aggravated assault deadly weapon at a hotel outside a curfew. He never was able to explain. Well, let me think about shooting himself in the foot over a lottery ticket with, is it Mufasa or is his name Mufasa? I don't remember. But he has a history of making this court look ridiculous in extending him. I don't know. It's been 3, 4, 5 chances, right? So we'll see you in 2 weeks.
Thank you. I'm sorry, Your Honor, I had to.
I know you do. Thank you very much.
I appreciate it. Thank you.
Bye-bye. Who's next?
Judge, if you want to do the interpreter next with Ms. Butterworth, page 15.
Okay.
It's the Mr. Guevara.
Who is it? Annex, if I could have Gustavo Guevara Arroyo, please.
Yes, coming up.
Miss Noyola, I see you. Okay, sorry. I have to get reused to seeing all the boxes on the Zoom screen. Once we get Mr. Guevara, I have reviewed the motion. Is that Guevara?
Arroyo.
Do you speak any English, sir? Do you speak English?
No.
So I did review the motion, Ms. Butterworth, and I understand it is basically the language barrier. Frankly, I've already granted it. Ms. Noyola, if we could please, Mr. Nanez, if you'll set the interpreter function.
Annex, if you'll select Spanish, please.
Yes.
Is it on already?
No, ma'am.
Okay. Okay, this is cause number 2024-0D06449, State of Texas versus Gustavo Guevara Arroyo. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
And good afternoon, Your Honor. Denise Butterworth on behalf of Mr. Arroyo.
And for purposes of the record, Mr. Arroyo is appearing remotely from the jail annex, utilizing the assistance of a court interpreter, Ms. Gloria Noyola. Ms. Butterworth has filed, sir, a motion to withdraw, the basis for that being that you are solely a Spanish speaker, and the court is in agreement, unless you have an objection, to appoint you a different attorney, one who is a Spanish speaker. Do you have any objection to that?
No.
Okay. I may have already forgotten. I can't remember. Ms. Hernandez, can you tell me who it is that I appointed?
Jesus Olivas, Judge.
Okay. And he has future settings, Mr. Arroyo does?
Yes, ma'am.
Okay, Mr. Arroyo, we have appointed you Attorney Jesus Olivas. He will continue with your case, so he will receive all future notices. I don't know if there had already been a recommendation. This is a more recent case. Is there a recommendation?
No, Your Honor. At this time, the state does not have a recommendation. We are still reviewing the case.
Okay, so we will be going forward. You will not have a new attorney. Ms. Butterworth, thank you very much for appearing today.
Thank you, Your Honor. May I be excused?
You may. Thank you,
Thank
sir.
you.
Ms. Noyola, we do not need her services anymore, Mr. Nanez?
No, ma'am.
Ms. Noyola, thank you very much for appearing promptly. If we could turn off the function, and who's next?
Okay, thank you.
Maybe we can get Mr. Roney? That's Judge Munoz has been waiting patiently for so long.
It's coming up.
Thank you. All right, is that your client, Mr. Munoz?
Yes, it is, Your Honor.
Okay, let's go ahead and call these cases. Calling cause number 2024-0D07471, 2020-0D06025, 2019-0D06786, and 2019-0D06627, each case style, the state of Texas versus Christopher Roney. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Max Daniel Munoz for Mr. Roney, ready to proceed, Your Honor.
And for purposes of the record, Mr. Roney is appearing remotely from the jail annex. We are scheduled today for bond hearings on all of these cases. However, let me see, all 7471 are probation cases. The 2024 case is set for a bond hearing, but it's a newly indicted case. I also understand that there is a P-file case in addition to the ones that we have scheduled today. We are set for bond hearings. Judge Munoz, you may proceed.
Yes, Your Honor. As my client is on probation, one straight and two deferred in your court. He's picked up a new case, and there's a case that has not been indicted. He does suffer from mental illness in which he does need his medication. Last time we were in court, and it was on January the 9th of 25. At that time, we asked that to the jail that he be provided with its medication. I have no idea whether or not he has been provided with the medication. There was an extended offer, and I believe the court has said no. So at this time, Your Honor, he lives in Northeast El Paso with his mother. He's not working, and I don't believe that he has money or the family has money to make any kind of bonds. If any bond can be made on all 5 cases now, it would be a very, very low bond.
Okay. All right, let me just double check as I'm going through these. The cause number 7471 appears to be at a $10,000 PR bond. So that won't be changing. Is he on PR bond on all of them? Ms.
Your Honor,
Nichols, can you tell me?
held.
I'm sorry, what?
He's currently being held only on the probation cases at no bond.
Okay.
The PR bonds were already posted, so he's only being held on the 2020 6025, 2019 6786, and 2019 6627.
But 6025, that's the one he's on straight probation, right? That one has no bond as well?
Yes,
That is
all 3 of these are no bond.
Okay, so he's only technically entitled to a bond on the 2 deferreds. But you're asking obviously for bonds on all. All right, anything
Yes,
else,
sir.
Mr. Munoz?
That's it, Your Honor.
Mr. Garcia?
Yes, Your Honor. So as Mr. Munoz stated, yes, the state did relay a recommendation at the last setting. However, the state does agree with the court's assessment that at this point, the best course of action should be a safe P, Your Honor. And I know he is entitled to a bond. Nonetheless, I think at this point, the best resolution to avoid further violations to probation is just I mean, if Mr. Munoz could agree to safe P.
I have to talk to him,
Mhm.
Mr. Garcia, and I like to take some time before so I can go up to the annex and talk to him. And I mean, we still have the new case, and we still have the unindicted case. So
Correct.
Okay, so in terms of 7471, obviously that's not going to change, Judge. He's actually at a $10,000 PR bond.
We did.
With respect to the remaining probation cases, Annex, I'm sorry, there's quite a bit of background noise. I'm going to ask if you would mute, please.
Yes, Your Honor.
Thank you. The bonds as to each of the probation cases is going to be $75,000 cash surety. We were discussing briefly, because I know this case or these cases were addressed in some form last week with probation status hearings is what I think happened. I'm not sure.
that is correct, Judge.
I did review his PSR in preparation for the bond hearings today. We discussed briefly, but so your client can hear whenever you have that conversation, what the court is proposing outside of the bond hearing is that I thought your client had a more extensive criminal history, but it appears his criminal history starts in around 2019 with the cases that we have him here on probation and of course the subsequent offenses. the court's proposal on these cases in terms of his probation cases is that if he is inclined to participate in treatment, I will make the recommendation that he be modified to safe P, but only if he is adjudicated to straight on the 2 deferred cases. He's already on straight probation on cause number ending 6025. He would also have to plead on the 2 new cases, which include 7471. And then, of course, we still need to get the P file case, but they're both drug cases. I think the P file case is a 3rd degree. If he did that, then, they would be convictions across the board and he goes to treatment. That's option 1. Option 2, if he's not inclined to take treatment, would be 4 TDC on all the non-state jail cases to include the P file, and then 1244A credit for time served on the state jail felony. Okay.
Okay, Your Honor.
All cases will be tracking with the new cases. So 7471 has a trial track and we'll go from there.
Thank you, Your Honor. May I be excused?
You may. Have a good day.
Thank you.
Thank you, Mr. Roney. Who is next?
Ms. Gallardo, Judge, page 18 for Jonathan Walton. Annex, can we get Walton?
Yes, coming up.
Are you there, Ms. Gallardo?
Yes, I am.
All right. Calling cause number 2024-0D04046, State of Texas versus Jonathan Richard Walton. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Teresa Caballero on behalf of Mr. Walton.
For purposes of the record, Mr. Walton is appearing remotely from the jail annex. We are set for a bond hearing. Ms. Caballero, you may proceed.
Thank you, Your Honor. Your Honor, my understanding is that my client has been in jail, let's see, incarcerated since 12/13/24. His wife has come in. They've been married for 11 years and they have 3 children together. And she came in and dropped off a non-prosecution statement, and she wants him back home. I understand where the court may not be willing to lower the bond, which I understand is at $100K, to let him go back home. But he does have a mother, and I have an address of 466 Vandalia Drive, El Paso, Texas 79927. And I was appointed on 11/19/24, and he cannot make the bond.
All right. So basically he picked up the violation notice. So the 100,000 is due to the PR bond violation. He picked up a resisting a VPO in November. Okay. All right. All right. Anything else?
No, Your Honor.
He also failed to report since June of 2024. So that's
okay.
That's okay. All right, Mr. Garcia.
Yes, Your Honor. So I wasn't aware that there was a non-pros for this case, Judge. I'm sure that that will, of course, reflect on my recommendation. And Ms. Caballero mentioned there was a bond for $100K. Your Honor, I do believe that's a bit excessive. I'm not entirely opposed to a reduction. However, I would defer to the wisdom of the court to set a new bond. Of course, he is entitled to a bond that would assure his appearance in all further proceedings, Judge.
He does have on his criminal history, he does have prior incidents of assault.
2020, Your Honor, correct.
And then he also has out of state. Let me go back. Is there any mental health concern here?
I'm not sure, Your Honor. I really couldn't comment on that. Mr. Walton, do you have any mental health issues?
Yes, Ms. Caballero, I have depression and anxiety.
Have you been diagnosed?
Yes, ma'am.
Okay. Were you undergoing treatment before your incarceration?
Yes, ma'am.
Okay.
So he has a couple of assaults out of, is this Virginia? from 2017 and 2018, more than one. Yeah. Not a good track record of following bond conditions, so I'm not inclined to lower it a whole lot.
Okay.
Gonna be a $50,000 split bond, 25,000 cash surety, $25,000 PR, no offensive contact with the complainant. Subject to testing, no new offenses, the gamut, possess no weapons. Yeah, and then would have to reside. You said his mother is here?
Yes. Where does your mother live, Mr. Walton?
My mother lives in New York, ma'am.
New York. Okay.
I'm sorry, where?
New York.
Yeah, okay. Northeast.
Oh, Northeast. I thought I heard New
Did
York.
you say, I'm sorry, did you say Northeast or New York?
New York.
Okay, I'm right. You're right, Your Honor.
Yeah. So we're just gonna have to have the no offensive contact, no weapons, no new offenses, curfew subject to testing. If he is on any mental health track, he is to maintain that as part of his conditions on bond. That's the order. Thank you very much. Monday.
One question, Your Honor. Since he has 3 cases, is it, I have 3 files. Violation of PO,
Mhm. The misdemeanors.
impeding breath. Okay. Okay, so I understand. Thank you.
Thank you very much. Thank you,
Thank you.
Mr.
Bye-bye.
Watson. Bye-bye. All right, who's next?
Ms. Bayan, which one are you on?
Mr. Wade Shaw.
Mr. Wade Shaw? Annex,
Yes, sir.
could we get Mr. Shaw?
Yes, coming now, Your Honor.
Thank
Page
you.
16, Judge.
Mhm. Give me 1 second on this one.
Did you see my recommendation on this one, Ms. Bayan?
And I just saw it as we were logging on. I hadn't seen it until right now. And so I haven't been able to communicate it to my client. And I was also going to ask in the alternative, so I can go meet with my client, give him options, because he has 100 and I added it up, 186 days. If you could also give us an option of a time served.
I'm not sure it'll be time served, but I can do a time rec.
Well, on 6 months because you're right. Sorry, it's a second degree. Sorry, it's not a state jail.
Correct.
Right. Oh, no, I don't want a time rec.
Okay.
Or maybe an option of the straight. Sorry, I was thinking it was a state jail. The deferred or straight, I can go talk to him on Friday.
So you want a straight as well?
I want an option, yes.
So 5 deferred or 3 straight?
Okay, and what's the underline on the 3? 3 probated for 3?
No, it'll be 10.
Okay, I'll go talk to him maybe later, but at least let's get through this. Thank you.
Ma'am.
I'm sorry, I had to look up the PSR here. Give me 1 second. Okay, so he's at, yeah. All right, calling cause number 2024-0D00152, State of Texas, Wade Shaw. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Edith Payan on behalf of Mr. Shaw, we are ready.
For purposes of the record, Mr. Shaw is appearing remotely from the jail annex. We are set for a bond hearing. He is at $100,000. Ms. Bayan, you may proceed.
Thank you, Your Honor. Yes, Mr. Shaw is being held on a $100,000 bond on this possession of a controlled substance. It's a second-degree felony. The date of the offense is December 9th, 2021. He was indicted on 1/24/24. He does not have any prior history. He does not have any felony convictions. It seems there was an arrest some time ago for possession of marijuana, a felony and a misdemeanor, but those were dismissed. At this time, obviously, the $100,000 bond is oppressive. He has been continuously incarcerated for 99 days since October 8th of 2024 on his rearrest on the capias on this offense. in candor to the court, Your Honor, he has been in and out on this same offense. And this is now, as I said, the date of offense was December 9th, 2021, but this is now his fourth arrest on the same offense, so we do need to move on. As the court may have overheard, the original plea offer had been for straight probation from this one area. I was never able to work it out, but I did just get a new offer from Mr. Garcia. He entered it in portal. So for purposes of this hearing, in the context of Mr. Shaw not being a flight risk, the offer is probation, either deferred, or we discussed an option of straight. He does not have any money to post this bond. Again, he's been sitting there for almost 100 days. He's not employed. He does have a mental health diagnosis, although there was not a 1622, but he has been on medication. Miss Brittany Johans, our social worker, obtained his MARS, and I reviewed it. He is on medication for anxiety, schizophrenia, bipolar, and he has been compliant. He's missed a day or two, but nothing unusual. Sometimes they're asleep and miss their medication, but aside from that, from November to present, he's been very consistent on his medication. We have referred him to the reentry program, so we would ask that he be released on a PR bond and be referred to reentry to be given the standard language to be released tomorrow so he can go to the rescue mission so we can try to resolve this matter.
So
Nothing further.
let me back up because Mr. Shaw, I have the PSR. I'm also looking at the violation affidavit. He was placed back in March 2024 on a $1,000 PR bond. He never reported to PR bond, or at least he didn't as of the first reporting date, which was April 14, 2024. The summary on the violation affidavit says defendant was placed on standard supervision, report once a month by phone. He last called on March 13th and has not reported again. They attempted to make contact with him to bring him back into compliance and provide court reminder via several phone numbers, text message, emails, and attorney, but all attempts were unsuccessful. Defendant has also failed to provide and maintain current contact information from CJC. Whereabouts are currently unknown. When I put that together with the PSR starts in Albuquerque, New Mexico. He has criminal damage to property, battery in 2014, kidnapping first degree. Then we go later into 2014, and there's an aggravated battery. Let's see, in 2015, contempt of court, he failed to appear in Doña Ana County. Santa Fe Sheriff's Office failed to appear on a misdemeanor charge. Then we come to Texas, and I think that's where we start here in 2018 with the drug case, which is what we have here. So I don't know what kind of ties he has to the community, but if there are any, it is not assisting him to be compliant with bond conditions. Those are my concerns on Mr. Shaw. Mr. Garcia, what do you have?
Yes, Your Honor. So after hearing of the extensive criminal history for Mr. Shaw, and I mean, this case, Your Honor, this was I believe there was a auto theft task force that was investigating a vehicle theft. It was a stop, and then Mr. Shaw was the passenger. They had some outstanding warrants, and they were in possession of 16.2 grams of meth. Your Honor, I believe from hearing that summary, I believe he is a flight risk. He has several non-reporting. He failed to report for PR as well as he failed to report in these other courts outside of the state. Your Honor, I believe the 100,000 bond at this time may be reasonable, and that's because of his extensive history. It appears that he is a danger to the community. He has kidnapping, he has batteries, and this one's a drug case, Your Honor. So I believe the bond is reasonable as set. However, I did relay a recommendation of 5 deferred. I think if we get a plea, that'll be the way to go.
Miss Bayan, I hadn't gone through all the entries. There was a 1622 back in October. What I don't see just offhand, without kind of digging into Odyssey a little further, I mean, I'm sure you all have looked at it, that there was a finding that there should have been a further examination of your client. So there was a mental health concern there. That might be an issue. Anything else on the bond?
If I may, again, I did not have access to the New Mexico information. I was just relying on what was in the portal. With regard to that prior 1622 in October, I found the order, but I couldn't find the actual 1622. However, I think at this point that's moot because he is being treated for medication. And he has been diagnosed at the jail. So that was resolved. As I mentioned earlier, he is on his medication. We do have an appointment in place for him with OSAR for the drug screening on January 29th at 11:30. As far as an EHN appointment through Takumi, we couldn't get that scheduled because at this time he doesn't have an address. So I was hopeful if we got him released to reentry to the rescue mission, we could get him that appointment and try to keep him stable and work this out.
So the court, do you have anything else on the bond?
No, ma'am.
Okay, the request to reduce bond is respectfully denied. However, hearing what you have on, in terms of appointments, if the court can assist in any way to have him brought over for any type of interview or exam, we're happy to do that. Just please make the request with the court. I don't know if it's doable. Sometimes Aliviana can come over and we do those kind of interviews here. We'll bring over your client. If we can assist to help make a clearer picture, happy to do that. The court is very concerned about his risk, prior criminal history, ties to the community, and obviously safety of the community, okay?
Your Honor, if I may though, could I just then clarify? So Mr. Garcia, we have the offer for deferred and an option also of 10 TDC probated for 3?
Yes.
Okay, thank you. Mr. Shaw, I'll be out there Friday or Tuesday to get this communicated to you, and then we can talk about it. And Judge, as far as those appointments, I think either way, they'll, as long as he's incarcerated, we won't need those appointments, but we'll work. Thank you for the offer.
Okay, well, let us know if you need anything. Thank you very much. Thank you, Mr. Shaw.
Thank you. May I be excused?
You may have a good day.
Thanks, you too, Your Honor.
Who's next?
Page 14, Judge, for Black Moon for Mr. Huffman.
That's mine, Your Honor.
Oh, 'cause I was like, oh, so Mr. Huffman really was supposed to be here. No. Andale, pues.
He is here.
I know he is. I saw him.
He's the James Brown of the courthouse, Your Honor. The hardest working man.
I know it. I know it.
But on Mr. Blackmoon, Your Honor, Mr. Garcia and I have agreed on a PR bond.
Well, hold on 2 seconds.
Blackmoon, Mr. Blackmoon.
We need to talk first.
The court.
So I explained the mental health issues that Mr. Blackmoon has, Your Honor, and this is a THC case. And he will be living with his mother. I can obviously provide the court and the clerk that information. And I think we can dispose of this case a little down the road. But I asked for the court to grant him a PR bond, especially considering the district attorney's agreed.
So let me get on the record. I'll just tell you off the record, I'm not in agreement. But let's get on the record so you all can put it all on the record. Calling cause number 2024-0D06454, State of Texas versus Michael Alexander Blackmoon. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rene Vargas on behalf of Mr. Blackmoon, ready to proceed.
For purposes of the record, Mr. Blackmoon is appearing remotely from the jail annex. I will state before we got on the record, I believe your client was already speaking, and so they're muted over there, Mr. Vargas. If at any point you need me to ask them to unmute, please let me know, okay?
Yes, Your Honor.
We are scheduled for a bond hearing today. He is at a $5,000 cash surety bond. As Mr. Vargas represented off the record, the state is in agreement with a straight PR bond. Let me hear what you have, Mr. Vargas, on the bond.
Well, Your Honor, my social worker, Brittany Johannes, has already contacted EHN Takumi and made a referral for him to walk in upon release. Upon release, he would be residing with his mother, Ernestina Morena Sosa, at 9435 Diana. And we have spoken to her, and she's aware of his mental health issues and could help transport him back and forth to EHN Takumi to get that done. He has had a past of significant mental health issues and has been in competency court. Those cases were dismissed after several years of pendency in that court. And that was in the interest of justice, considering all the circumstances and the unlikelihood that Mr. Blackman is going to regain competency. Given the level of offense on these cases and his relative stability, Your Honor, he hasn't committed any subsequent violent offenses. I think the court would agree that this is perhaps the most benign felony that exists, is the THC vape pen. It's been indicted as a third-degree felony because he had 2 of them, but they were vape pens. He does have a prescription out of state for medical marijuana, so it's not completely self-medicating, Your Honor. I think that the best track right now is to have him live with his mother, attend mental health counseling, and if we can prove to the district attorney and to the court that he maintains stability, is getting mental health treatment, I think we can dispose of these cases rather than heading down the same road that we did with those 2019 cases.
Is he receiving treatment right now in the jail? Because I don't, I'm not a mental health professional, but
He's on medication, I believe, Your Honor.
Yeah. Do you want me to?
I have listed on the form that my social worker provided that he's on lisinopril, Depakote, and other psychotropic medications, Your Honor.
So that is, he's currently taking those meds in the jail right now? He's not.
I believe so, Judge.
Okay. Look, let me tell you a little bit of what I'm seeing on the PSR, and I'm absolutely understanding the mental health argument that you're telling me right now. Okay. We're going back. Let's see. He is from here?
Yes, Your Honor.
No, he's not. He's shaking no.
He was living in Denver, Your Honor, but he's from here and his mother lives here, and that's where he will reside.
Okay, so in
Mr.
2021,
Mr. Blackman, if you get out and the court, you can't. If the court directs you to live with your mother, that's where you need to live, Mr. Blackman.
yes. Yeah. Just a second, Mr. Blackman. I'm going to tell your attorney some things, and then if we need to go to a break, if you need to go to a breakout room, we'll do that.
I think I do, Judge. Thank you.
Okay, let me just go over a couple of things. Yes, he has an extensive history outside of El Paso County. So Denver, I have, let me see. Well, there's a fugitive. It just says felony dismissed. Trespassing in 2021, damage to property, disturbing the peace, making a false report. And I understand, I get it. I get the mental health part. I really do. Harassing communication, that's 2021. Obstructing justice, 2021. This is all Denver. Burglary of a building, dwelling, trespassing, damage of property, harassment, inconvenient hours. 2024 in Denver, May, felony damage to property. June, failure to appear. How long has he been in custody?
84 days, Judge.
Okay, so failures to appear on a subsequent August 2024 entry. And then from September forward, a ton of failures to appear through September 2024. Then I go to Florida. And Florida, let's see. Incident date, May 2017. Fugitive, fraud. 2017, Miami-Dade. Hired vehicle, failed to redeliver. And then we get to Texas. Texas, we start here in May of 2019, and those I'm sure you've probably seen, but he's been booked. I mean, he's had cases come up 2019, assault on a security officer, criminal trespass. The frequency of the incidents are what make this difficult. All right. Mr. Garcia, go ahead.
Well, Judge, as the court mentions, there is a pattern in the frequency of the reoccurring offenses. Now, Judge, my concern is the following. So if he is, if there's a, if, as Mr. Vargas stated, that he is unlikely to regain competency, so what's going to happen with the case? I mean, I don't feel comfortable dismissing it because we're going to be back here in a couple of months.
Well, so, but yeah, you're not comfortable dismissing it. I'm not suggesting that you should, but why
Right.
should I be comfortable letting him out into the community where he may commit new offenses? Because,
Correct, Judge. So for that reason, I do believe that the bond is reasonable as set.
oh, okay. I thought you guys agreed to a PR bond.
I did, Judge. However, I mean, we're listening to all that's happening. I hadn't had an opportunity to see Mr. Blackmoon. Now I am. And so my concerns are there, Judge.
And if I may respond, Your Honor, I mean,
Yes, sir.
we're only considering the present offense here, which is a THC case, a third-degree THC case. He hasn't presented with any violent conduct nor any property crimes, Your Honor. You know, to be completely cynical, if he does move back to Colorado, where the laundry list of crimes you listed run, then he becomes Colorado's problem, not Texas, not El Paso County's problem. This office and this county has been down this road with Mr. Blackman before. I think that this may be the best alternative, is to release him to his mother to get mental health treatment here, considering, like I said, the level of offense here in El Paso County.
Yeah. Okay. All right. The request to reduce bond is respectfully denied. Your client is still indicating that he wants to speak. If you want to go into a breakout room, Mr. Vargas, it will have to be just, we don't have a whole lot left on the docket, but if you'll need to stick around just so we can finish the last couple of cases.
It shouldn't take very long, Your Honor, like
Okay.
5 to 10 minutes. I appreciate it, Judge.
Mr. Blackmoon, we just need to handle some other cases and then we're going to bring you back because your attorney wants to speak with you, okay? Thank you. All right, who's next, Mr. Nanez?
Judge, page 15 for Joanne Mata for Mr. Huffman.
All right. Oh, okay. Are you all aware Ms. Mata is a complaining witness in P file 2024, 2024 P file 12761. The defendant there is Juan Mata, the CW to this case. Just letting you know.
I was not aware, Judge.
I was unaware also, Judge.
Okay.
Does that create a conflict for me, though?
Good.
I think it does.
I need to find out if
So let me I'm familiar with Ms. Mata's case, not because I've seen her a whole lot, but because when I received the KPS request from PR Bond, I did, I do my homework sometimes when I'm looking at these requests to pull bond. And that's where I saw that it's really within days of this assault family violence. She's the complainant in the assault family violence that is defendant Juan Mata. It appears from those documents that they're, spouses. She has an extensive, Mr. Stevens, I reviewed the PSR. She has an extensive criminal history. A lot of it is primarily Farmington, New Mexico. I think that's San Juan County, Albuquerque, and a lot of failures to appear. So she's at $100,000 right now. The complainant has not, I can't remember if he's been booked. I think he posted bond on his assault family violence. So he's out. But there appears to be a history here. So
He did contact the office, Judge, Mr.
he's
Mata.
a defendant.
Right.
Yeah. So do you want to proceed, Mr. Stevens?
yes, please, Judge, I appreciate it. I do know that Mr. Mata has been contacting me as well. The offer on this case is dismissed with mental health treatment. I know that we had planned that my client would live with Mr. Mata. However, I did ask her if there was if she would have it in a place to live if the court would not allow her to live with Mr. Mata, which apparently that is not going to happen.
Yeah, there is
Oh.
the protective order still active?
I do not believe so, Judge, and the violation of bond is actually because of the PR bond, not because of a protective order. Because the PR bond stated no offensive contact with Mr. Mata. And it also said, no weapons. She had a kitchen knife allegedly when she was, found, and, the allegations are that she was trying to harm herself.
Right, she said she was
So-
gonna kill herself before she went to jail again.
So she was arrested for violating that PR bond. When I asked her if she had a place to live other than with Mr. Mata, she stated that Mr. Mata could go live with his mother if needed, because she currently lives with her two daughters. One's 17 and one's 18. And then her husband, Mr. Mata, and his son. Her husband and son can go live with her husband's mother, with Mr. Mata's mother, if she's released. I would have to just get that cleared with Mr. Mata and get his agreement. Because he has been in contact with both of us. My client's 39 and she was born in Farmington, and I know you mentioned her history in Farmington. She's been in El Paso since about 2016. She had disability in New Mexico and was getting treatment in New Mexico, but lost that because of living in Texas. And they have applied in Texas for coverage, but they're appealing that. My plan was that she go to Takumi and be treated with Takumi in the meantime. And just follow through with mental health treatment in the meantime with Takumi. She does have a cosmetology certificate and some other college and some college work. She has in the past used drugs, but she denies current usage. But I will say that when this was happening, my understanding is that she was off her medication. When I talked to her, she was mentally competent and able to communicate with me well. So I was feeling pretty comfortable about our plan until I heard what you just told me.
The reason I asked Mr. Stevens about the protective order is because she's got a pending violation of protective order from December.
Correct.
And so, they're not supposed to be together.
That one, again, Judge, was a violation of the PR bond. It's a violation of protective order or bond. And when I read the affidavit, I believe that the allegation is they're alleging that she violated the PR bond with offensive contact and having that kitchen knife.
Got it. Yes, you're right. It's not based on a family violence.
However, if there's a new case with Mr. Mata as the defendant, then
There might be one on him.
there might be.
Messy. All right. Is your client being treated with meds in the jail at this time?
Judge, as of yesterday, according to the jail, she had not been treated yet. She's not receiving medication at the jail. They responded no recent psych eval and not currently on any medication. So I don't believe they've seen her yet. She was arrested December 27th.
Right after Christmas. All right, Mr. Garcia, did you have anything else, Mr. Stevens?
No, Judge.
Okay, Mr. Garcia?
Yes, Your Honor. So here we do have quite a bit of history of assault family violence cases. We had a 2018 conviction and a 2020 conviction, and then a couple of dismissals, 2017 and 2020. There is also, as you mentioned, there's a violation of protective order pending. Your Honor, I wasn't aware that the defendant was the that she was a victim in another case. And so the defendant reached out to the victim reached out to us saying that he doesn't want to prosecute, that he's never wanted to prosecute this case, that there is an alarming issue with mental health. And that's the reason for my recommendation, Your Honor, to receive mental health. I am opposed to a full PR bond because of the history, Judge, the family violence history. And of course, it appears that they continue to be in touch even though they're not allowed. So, Your Honor, I'm opposed to a full PR. I am not opposed to a reduction of the bond, just to a reasonable one that would assure her appearances in all future settings. I will tell Mr. Stevens again, my recommendation will remain the same. I do believe she needs mental health treatment. And if she is enrolled in any sort of treatment, we will try to dismiss this case.
So her history, just so we're not, just talking so generally, it's an extensive rap. It's an 18-page rap. Mostly violent offenses starting in 2009, aggravated battery, aggravated battery against a household member, that's 2008, 2009, aggravated battery, 2010, forgery, issuing or transferring, forgery, she pled guilty to a lesser, Farmington in 2011, abuse of child, that was ultimately dismissed because she completed anger management and provided the court proof of that. 2012, failure to comply, concealing identity. 2012, contempt of court. 2012, failure to comply with some requirements, failure to appear on a misdemeanor charge, contempt of court. 2013, failure to appear on a misdemeanor charge. 2013, assault. 2014, disorderly conduct and battery. 2014, contempt of court. 2014, in Albuquerque, false imprisonment, abuse of a child. Does she have children? Yes, she does. You said her 2 daughters, right, Mr. Stevens?
Yes, Your Honor. My understanding is that they are 17 and 18 years old.
Okay. 2015, in Farmington, aggravated assault on a peace officer, resisting, evading, or obstructing. 2015, failure to comply. 2015, same thing. 2015, same thing. 2016, same thing. Yeah. 2017, we get to El Paso, and we have more assaultive. She's been in the 409th. Criminal mischief, CCR1 dismissed, assault, class A, 3rd degree in the 41st. She was placed, she got revoked, I guess. She was placed on probation 10 years in 2018 in the 41st, and she ends up getting revoked to 2 TDC in 2023, and we're already back. Yeah. All right. The request to reduce bond is respectfully denied.
Okay, thank you, Judge. And I will follow up with the jail concerning her mental health treatment.
Yes, sir. Thank you, and let us know.
Yes, ma'am.
Thank you, Ms. Mata. Who's next?
Page 15, Judge, for Medina. Jail, can we get Medina?
Yes, it's coming out.
Thank you.
Huffman, are you on this one? He's not booked on this case.
He's not, Judge. There is a pending warrant. He's booked on a misdemeanor.
Mm-hmm.
He's unable to bond out on that because the bond companies see this this $100,000 warrant. So,
Well, he needs to get booked on this.
well, it's the jail knows about it. I'm sure it's in the system, and why it hasn't been booked, I can't say. But it's affecting his ability to bond out, Judge.
Is he here, Mr. Medina?
That's him.
All right, calling cause number 2024-0D0951, State of Texas, Marcos Medina.
Yes, Your Honor. Jose Garcia for the state, present and ready.
Rick Huffman on behalf of Mr. Medina.
Mr. Medina is appearing remotely from the jail annex. He's at a $100,000 bond. As I noted off the record, Mr. Medina is not technically booked on this case, but it was, I believe, a PR violation. You may proceed, Mr. Huffman.
And Judge, just to clarify for the record, there's a warrant right now for $100,000 bonds on this case, and he's not booked on it, but I mean, I would, you know, ask the court to consider this bond reduction because it is affecting his ability to bond out. Judge, Mr. Medina has lived in El Paso his whole life. This assault case is an allegation against his girlfriend. She has given my office a non-pros. She basically said, Judge, in the non-pros, that there was no physical contact other than some rocks being thrown to and from the complaining witness. Like they were throwing rocks at each other. A window got broken and the complaining witness got upset and called the police. She does want the charges dropped, though, Judge. Your Honor, we've been arraigned, or we were set for an arraignment, Judge, and I think Mr. Medina had missed the arraignment, but then I quickly got in contact with him through his dad, and we filed a motion to recall the warrant for no-show. But he was arrested a couple times since then, and but we do have contact with him. We do have he does promise to appear at all future court dates, Judge. I've had my social worker speak to him. He's never been diagnosed with a mental health issue, but he thinks he may have some bipolar and some other mental health issues. Currently, Judge, he's homeless. He's been homeless for about 6 months. His mom lives here in El Paso, but currently she's at in Dallas because his sister had children and she's there to help care for the kids there. But we did confirm, Judge, that there is a bed open at Casa Vida. My social worker did confirm that with the Mario Medina, who works in Casa Vida. So he's welcome to go to the Casa Vida and there's room for him, Judge. It's a 90-day treatment program where they will basically give him substance abuse treatment, mental health treatment, and it's not a lockdown facility, Judge, but I think it's a good option for Mr. Medina. He wants to go to Casa Vida. Judge, we've also confirmed that if we put some language in the bond order, that the people from Punto de Partida will pick him up and actually pick him up from the annex and actually drive him to the facility. Let's see what. Just one second, Judge. I just need to pull up. He's agreed to be assessed for mental health treatment. I think it will help him. Judge, we don't have we've got some unfiled cases. We are set for an examining trial in the possession case. There's the offense date on the new cases is 10/25/24. I have not seen the complaint affidavit in those cases. According to my clients, he was at a car wash. Police mistakenly took him for a suspect that they were looking for, but he was obviously not the guy, and he was beat up and searched illegally. But obviously I don't have the complaint affidavit on that. He's bonded out on that. Judge, we're asking the court for a reasonable bond right now. It's like I said, $100,000. And I think that's all I have, Judge.
I show him booked 5 times in 2024. He's been booked 5 times in 2024. Is that following bond conditions, you think, or not? So let me go over his PSR. In 2013, I have an evading arrest or detention, CCR 4, guilty. In 20 2013, a POM, guilty, CCR4, got 5 days. 2013, robbery, 1244 ADM to a lesser, 50 days. Plano PD, and a Class C assault, okay. 2017, harassment of a public servant, pled, 2 years probation. Looks like he expired there in 2019. 2020, assault, family violence, dismissed. That was a misdemeanor, CC1. 2020, continuous violence against the family. Maybe that got re-indicted. It was in the 409th. He pled to deferred. He expired in 2023. Is this, yeah, okay. Continuous 3, okay, where was I? 2020. Violation of protective order 2 times within 12 months. That was dismissed. Are these the same victim?
Let me take a look, Judge.
409th, burglary of habitation, dismissed. 2022, interference with a request for police assistance in Anthony PD, guilty, 30 days. Yeah, criminal trespass, dismissed. And then I think we get here, June 2024, assault prior. Says there's a July POM that was dropped by the agency. So are we learning any lessons, you think?
Well, Judge, I think so, Your Honor. He's been in custody this time around for 37 days. And, you know,
Because he was out on bond and he picked up a resisting, right?
well, that resisting, I think, was more like
And a drug charge. I'm sorry, I forgot the drug charge.
I want to say there was one pill in his pocket, Judge. We don't know obviously what that pill is without the lab reports, but the resisting was I think it's questionable. And this time around, Judge, you know, we've referred him to Takumi. He's got a 90-day program at where they offer a lot of different services, Judge. You know, maybe it's a mental health thing. You know, maybe if he gets stable mentally, he will stay out of trouble, Judge.
Okay. All right. Do you have anything, Mr. Garcia?
Yes, Judge. So, I mean, I'm thinking 2 things here. One, this is either a time case or a safety case. That's because of the fact of the reoccurring offenses. Of course, we spoke to the complaining witness in this case. She told us there was a severe drug abuse issue with Mr. Medina. Your Honor, I did recommend some drug treatments. I wasn't aware that there were other cases pending. Now I am. So for that reason, Judge, I believe the safety would be appropriate recommendation for this case. Your Honor, the current bond is set at $100,000. The state would agree to reduction no less than $75,000. Again, he keeps reoffending, Your Honor, so we think the bond may be reasonable at this point.
Mr. Huffman?
Well, Judge, he can't afford a $75,000 bond. He just can't. He's homeless, Judge, and he's been found indigent, and we believe that bond would be excessive.
The court would disagree, deny your request to reduce bond due to the continued criminal history, safety of the community, safety of the victim. He is apparently not able to follow any conditions, so I'm not inclined to put him on any kind of bond that he can make.
And I'll reach out to Mr. Garcia and you know,
okay,
talk to him about that offer. Maybe there's a middle ground, Judge.
Safety sounds good. BHRTC maybe. All right, thank you very much. Thank you, Mr. Huffman. Who's left?
Page 17, Judge, Jacob Versosa.
Coming out, Your Honor.
Oh, good. So we got a new case, arson. And our pre-revo. These are, let me see. Oh, when did he plead, Mr. Huffman?
I want to say in September. He wasn't my client, Judge, but he probably got put on probation in September or October of this year.
And let's see, he pled September 17th on the prior assault, unlawful possession by felon. And then on November 5th, he picked up the new cases, right? Arson.
The arson case in that case has been indicted.
Okay. Well, I mean, we're looking at time. I know, I mean, we're just gonna carry this probation case with the new case.
Well, Judge, we're hoping that the court might consider a mental health treatment. This new arson was clearly a mental health issue. There was no real damage to the property. It was a Motel 6. He was having a mental health breakdown, Judge. I don't think he was on his medication when he got out of the jail and put on probation. He was not, I don't think, on the mental health caseload, Judge. That's where he needs to be. That's the only, I think, the best chance for rehabilitation, Judge. And so I think there's a lot of mitigating circumstances that the court might consider. And I don't have any there's not a long time on probation, so I don't think there's much as far as violations, technical violations, but you know, if being yeah.
Let's see what the state wants to do with the new case.
Well, Judge, and as Mr. Huffman mentioned, so he pled on September 17, and already by November 5th of that same year, we had filed the motion to revoke because of 1, 2, 3, 4, 5, 6, 9, 8,
Garcia, let me go back. In 2014, he's already been to TDC on an ag assault deadly weapon, AFV with a previous, driving while intoxicated, third or more. I mean, Mr. Huffman, we're going to carry the probation case, okay? But he's already been to TDC.
He has, Judge, and I think that is I think there's a reason that he got put on probation, Judge, and you know, I haven't really looked into the old underlying cases, but Judge, we're just hoping we get him a fair shot. I mean, he's got some mental health issues that might give him a better chance.
I think Carla's going to say something. Carla, were you going to say something?
I mean, the only thing, he never reported, so we were unable to screen him or follow up with anything. He never reported that 1 month and a half, and then he got rearrested right away.
Yeah, okay. Mira, we're going to carry the probation case, get your waiver of arraignment in, and we'll see where we are. Okay?
And I have a jail call scheduled for Friday, Mr. Versosa, so, you know, we'll talk, okay?
Thank you. Annex, if I could have Mr. Vargas's client, Mr. Vargas, Black Moon, is that who it is?
Yes, ma'am.
It's your honor, the one and only.
Kind of nice to see everybody. New year, everybody's here. All right. So in terms of Mr. Vargas, are you going to need us for anything? Okay.
No, your honor.
Everyone else is excused. Mr. Nanez, if you will create, well, if everybody gets off, you don't need to make a breakout room unless Mr. Vargas.
And just so the court and Mr. Garcia know that I'm gonna have to file a motion to comp Mr. Blackman.
I was gonna ask for that. I mean, honestly, I think that's where we're headed. So just let me know. But if everybody will get off, then Mr. Vargas can do his thing.
Okay, thank you, Jim.
Thank you.
You know what Apple Pay is? I have Apple Pay. I can pay my bond with Apple Pay. I have $14.2 billion. I was arrested.
Be quiet, Mr. Black Moon. All right, everybody's gonna exit so that you and I can talk, okay?
Right.
Will you get Alex and Brittany, please?
Are we ready?
So
No, that's all. These other.
First, Amanda. I need the Amanda. Remember, I'm ADA, Americans with Disabilities Act. There's a
Ms.
specific.
Frizzell?
Amanda Ferrisell. Very
Be
self.
quiet.
Where's Samantha?
Michael, be quiet. You and I are gonna talk right now. The
I'm
court
a
did
lawyer. I am a doctor. Do you believe that? Why don't you believe that? RamosLaw.com. Ramos Law is my doctor and my lawyer. He's just like me. Denver, Colorado. Black Moon and Company, a due diligence and compliance company. Auditing the government.
logging off, so it's just me and my client, so that we can have a. As soon as I hang up, the Zoom call will end.
Okay, sir, I can't close myself out because then I'll shut it down. So can you put you in the breakout room or I can just black myself
Yeah,
out?
put us in the breakout room, please. Thank you. I'm sorry about that. I
When you're done,
appreciate it.
when you're done, just go ahead and exit yourselves, okay?
Okay.
Same with
Hey,
you, Annick.
Michael, let the DOs know to click for us to go into a breakout room. There's gonna be a little button that pops out that says breakout room.
Yes, sir, we're waiting.
Okay, thank you.
Hold on.
Do you know how to read? Do you know what it says in the back?
Take a seat.
Illuminati. Illuminati. That's a shitload of money. Do you have that kind of money? No.